Law 578, Law of Evidence 2, Lecture 2, Witnesses and Corroboration. Assalamualaikum warahmatullahi wabarakatuh. Okay, in this video, we are going to proceed on to look at several witnesses where evidence require corroboration. We have looked into the concept of corroboration, the meaning of it. We have looked into the requirement of corroboration under the law in cases of child witnesses. So in this video, we are going to proceed on to look at another category of witnesses, that is victims of sexual offences. Now, if you look at this PowerPoint here, you'll find that when you are dealing with evidence of victims of sexual offences, corroboration basically required only as a matter of practice and prudence. It means that it is not mandatory for corroboration to be supplied whenever a victim of sexual offences gives evidence in the court. Corroboration warning need to be given by the court in analysing or assessing the evidence of victims of sexual offences. Now, why is this so? This is so not because the victim of sexual offences, when they are giving evidence, they are not reliable, but it is because the nature of the offence is so vulnerable, is as such that there is a tendency or there is possibility that witnesses of sexual offences victim, when they give evidence in the court, it can be motivated by factors such as malice and jealousy. Right? That is why in the case of DPP or in the case of Dane against DPP, whenever you have victim of sexual offences giving evidence in the court, the rules of practice and prudence require their evidence be corroborated. Right? As I told you just now, it is understood that evidence of victims of sexual offences, as a matter of prudence and practice, need to be corroborated. However, it is not a matter of law, meaning to say that there is no rule of law that requires them to be corroborated. Right, if you look at that, the case of PP against Mardai here, it says that, conviction is unsafe unless the evidence of the complainant is unusually convincing or there's some corroboration of the complainant's story. So it means that if you have a witness here giving evidence in the court, it is safe to convict unless there's something wrong with the manner in which the evidence was given, in the sense that the evidence is so unconvincing, and if there is corroboration, then it's okay for you to convict. Again, if you look at the notes here, if you are dealing with child evidence which has been raped, so you have a child here who are victims of sexual offences, the more you need to have their evidence corroborated because of the element of a child. If you recall in the previous lecture, whenever you have a child giving evidence in the court, of course the child evidence requires corroboration. Right? Similarly, in the case of Palwan Singh, you have a child who is mentally retarded. In this situation, corroboration is necessary. Now, what are examples of corroboration? Right, examples of corroboration: when you have maybe issues of rape, you want to call this particular complainant to give evidence in the court. Right? So you have basically a situation where you have an accused person here, right, who is alleged to have raped a victim. So you have this victim being victim of sexual offences. They're required to give evidence in the court. Basically, if they are to testify in the court, the law says that as a matter of prudent practice, their evidence has to be corroborated. Now, how or what kind of corroboration, what form can corroboration take? If you recall the law relating to corroboration in the previous lecture, remember, corroboration can either be by direct evidence, it can also be by circumstantial evidence. Example of corroboration will be the fact that the victim here made a police report. She made a police report as soon as possible. And when she made a police report, right? The relevancy of her evidence of the police report is basically will be regarded as evidence of conduct. This will be under section 8 illustration G. Now if you look at section 8 illustration G, now have a look at section 8 illustration G, you find that the question is whether A was ravished. The fact that shortly after the alleged rape, she made a complaint relating to the crime, the circumstances under which and the terms in which a complaint was made are relevant. So it means that if the victim here made a complaint at the police station, the reasons why she made a complaint at the police station may be because to illustrate her position. So you are talking about her position here, the victim's position here. This will be relevant to reflect her conduct as to why she made a police complaint. Maybe because she was in fear, right? Maybe she was afraid. So when you tender evidence of when she made a police report here, the police report here, which can be regarded as maybe a documentary evidence, this police conduct will be reflective of this police report, which is a documentary evidence, will be reflective of the victim's conduct as to why she made a police complaint, right? So that's why when you talk about victim here making a police report, which is reflective of her conduct, it can be corroborative evidence reflecting that she could have been raped. Because, and of course, in this situation, you have to do your police report as soon as possible. Having said that, sometimes you have a situation where a person has been raped. So if you have a victim here, say for example she is a 18-year-old girl, and this is a boyfriend here, A, who is 23 years old, right? She made a police report, say for example 1 month later. If she made a police report later, that can be an indication that this could not be a genuine case because of a delay of 1 month. Because if you look at the definition of complaint basically can be regarded as conduct of the victim. Under section 8 illustration J, basically the meaning of the complaint here has been explained in the case of Aziz bin Muhammad Din, whereby the complaint must have certain element for it to be regarded as a complaint. For example, it has to be made to person in authority. Yeah, it has to be made to person in authority. And in this case, of course, you have the police. It has to be made as soon as possible. It has to be made with a view to redress. Now, what happened in the case of Aziz bin Muhammad Din is that, remember, this is a case where the child here, who is the victim of sexual offences, and Aziz is basically the boyfriend of this particular girl. She made a complaint, of course, to a person in authority as soon as possible because she made a complaint 1 or 2 days later, with a view to redress perhaps. However, the problem with the child in Aziz bin Muhammad Din is that there is no element of voluntarily. So complaint has to be made voluntarily. What happened in the case of Aziz bin Muhammad Din is that she made a complaint upon being told by the father, who was unhappy with the situation. So there was no voluntariness in the complaint made by the girl. Therefore, the court says that this is not a complaint which can reflect the victim's conduct. Okay? So for that to be a police complaint, of course, it has to have the element that is stated in the case of Aziz bin Muhammad Din, and complaint has to be made as soon as possible for it to be regarded as a good complaint, meaning to say that there's absence of element of malice or other kind of motivation. So if you look at the example here, you have a girl here who is 18-year-old and the boyfriend here who is 23-year-old. And she made a complaint maybe 1 month later, that is maybe perhaps after she has missed her period. So there could be an element of malice as to why she now claimed rape, because the relationship between A and V here maybe is not rape cases. It could be a consensual sexual intercourse. However, because of the delay, she's now pregnant perhaps, so there's a need for her to make sure that the accused person here be responsible for what happened to her. Maybe that could be the reason why she made a complaint. So in this case, it reflects that delay in making a police complaint may be a factor that may result in the witness here losing the credibility when she testified in the court. Now, having said that, the case of Hairani Sulong and also the case of Ahmad Nazari reflect that it is not at all time that delay in making a complaint will not amounting to corroboration. Right? What happened in the case of Hairani bin Sulong is that the court says that for you to rely on the police complaint as evidence of corroboration, you cannot just simply look at the day or when the complaint was made, but also you have to look at the whole situation. Right? Evidence of delay should be considered in light of other relevant evidence. So that's what's said by the case of Hairani Sulong. In the case of Ahmad Nazari, what happened was, in the case of Ahmad Nazari, in this case, you have the woman who has been raped, a 63-year-old female rubber tapper, who was illiterate, who was old, but she has been raped twice in front of the husband by the accused person. And in this case, what happened was that there was a delay of making a police report about 3 weeks after being raped twice. And in this case, the court says that by looking at her condition, by looking at the circumstances, the fact that she was illiterate, she was aged, and maybe the element of embarrassment, this may justify why she was late in making the police report. And by looking at that, the court says that even though there may be delay in making the police report, it doesn't matter. It will not going to basically defeat the use of police report here being her conduct as evidence of corroboration. Alright, examples of other corroboration, basically you have evidence of medical report. If you recall the case of Siddiq bin Ludan, we have incidents, we have basically the medical report that is a check. So basically the victim here has been examined by a doctor. The doctor can determine whether it was consensual or whether it was rape. So the medical report here and the doctor here who examined the victim can give evidence which corroborates. However, when this particular person here giving evidence of corroboration, so you have a doctor here and the medical report here tendered as evidence in the court, it can only corroborate the fact that there was sexual intercourse. The evidence of the doctor and the evidence of medical report here does not corroborate the fact that there was or was not consent. If you recall, when you talk about evidence of rape, you have elements that you have to prove. There will be penetration and there will be consent. If you have offences of statutory rape, if the victim of this case, the victim of rape is someone below the age of 16 and below, basically you are relying on statutory rape, then the medical report will be of good evidence. However, if you are dealing with the victim who is an adult, because of the element of consent there, medical report and the evidence of the doctor here that can testify the fact that there has been penetration, it will not going to corroborate the issue of consent. Okay? Right. So basically that is the position of victim of sexual offences. Right? Now let's look at the notes back. So you find there, so this will be examples of corroboration in the notes here, right? And if you have, again, I told you just now, statutory rape situation, then evidence of corroboration will be evidence of police report will amounting to, will be good, to corroborate incidents of rape. And now, in the last lecture, we have looked at issues of corroboration in section 157. So basically, when you talk about a witness here giving evidence in the court, so if you have, right, you have here A has been alleged to have raped the victim here. If you have the victim here telling the story to witness number 1, the friend, witness number 2, you have victim here tell the stories to the doctor, right? So all this evidence given by these particular witnesses here in the court will be what? Repeating what the victim was saying. The law, yeah? If you refer to section 157, basically says that this particular evidence here is evidence of the source is the same, so it can be amounting to corroboration, but it's going to be very, very weak corroboration, right? So if you look at this one, basically under section 157, statement under section 157, now have a look one more time, the section 157. Now section 157, basically, let's see. Right, former statements of witness may be proved to corroborate later testimony as to the same fact. In order to corroborate the testimony of a witness, you find that in section 157 they use the word corroborate, right? In order to corroborate the testimony of a witness, any former statement made by him, whether written or verbal, on oath or in ordinary conversation relating to the same fact at or about the time when the fact took place, or before any authority legally competent to investigate the fact, may be proved. So you have a situation, say for example, A was alleged to have raped V on the 1st of January 2020, and upon incident of rape, the second day on the 2nd of January 2020, V informed the incident of rape to W1, W2, and the doctor. Basically, she met the doctor perhaps on the 3rd of January 2020, and she told the doctor the fact that she has been raped. So basically, if you refer to 157 here, that statement made by victim here to W1, W2 and the doctor here is amounting to corroborating the testimony of his witness. So W1 here will become prosecution witness, W2 here will become prosecution witness, doctor also will become prosecution witness. Their evidence, when they are repeating what the victim was saying, will amount to corroboration under section 157. Alright, so this is corroboration. But remember, the corroboration under section 157 here does not comply with the meaning of corroboration under the common law, which was explained in the case of Baskerville. Right? So if you look at the case of Baskerville, remember there are certain elements. Among them is that the corroboration has to be an independent evidence. That's why in Malaysia we have several cases which reflect the position of law on section 157. You have the case of Kartiyayani. Right, this particular case says that if at all section 157 is regarded as corroboration, it's going to be a very weak corroboration evidence. Right? Okay. Now let's look at the notes on which reflect this position. So you have that this case, so it is a very weak corroborative evidence. So it defeats the object of corroboration under the common law in Baskerville. Basically, the law further says that you have to distinguish corroboration, admissibility of a particular statement under 157 with the one that reflect the weight attached to it. So basically, you find that yes, in Malaysia, right, corroboration can come from the witness themselves when their statement is repeated by another person. However, it's going to be a very weak corroboration. It only reflects consistency of the statement. Okay? Alright, so that is actually the position of corroboration when you are dealing with victims of sexual offences. The law basically says that it is not mandatory for you to corroborate the evidence of witnesses of sexual offences. It is a matter of prudence and practice for you to corroborate, and corroboration is basically corroboration warning is required. Now let's look at the next witness. So we are dealing with accomplice giving evidence in the court. Now, can accomplice give evidence in the court or not? Now, when we talk about issues of accomplice, is an accomplice competent to give evidence in the court? So basically, two issues that you got to look at here when you are dealing with an accomplice. So whether they are competent to testify, whether their evidence require corroboration. Now, what is the position of an accomplice? Right, in the first place, when you are dealing with an accomplice evidence, you have to bear in mind and be very clear as to who is an accomplice, right? Who is an accomplice here? There are several case law that discuss who an accomplice is. Basically, you have the case of Davis against DPP, you have the case of R.N. Mullins, you have the case of PP against Abdul Aziz. So, basically explains that accomplices are persons who participated in the commission of a crime with the accused person, right? However, accomplice here is now giving evidence for the prosecutor against an accused person. So what happened here? Okay, who is an accomplice? You may have a situation where you have A1 and A2 here. They involved in the commission of the crime, and P3, right? And P, and P, right? So you have A1 and A2 and P. So what happened was that A1 and A2 is the one who commit robbery. So they intend to commit robbery at maybe Maybank at section 13 Shah Alam. So A1 and A2 was the one who entered into the premises and robbed the bank. And P will be someone who assisting them, who is on the lookout. He was the one who bring them to the Maybank. So he was basically in the car, stay in the car, ready to run, So what happened here is that while they commit robbery, right, and eventually A1 and A2 here been caught. P here managed to escape, right? So the issue here now, so now what happened here is that, say you have the police managed to capture all three of them. And however, P here has a deal with the police and the prosecution. Eventually what happened here is that A1 and A2 here are charged for robbery under the penal code. A1 and A2 becomes accused person 1 and accused person 2, who is currently charged for robbery. P, who was their friend, who brought them to the scene, who brought them to commit the crime of robbery, and basically on the lookout, is now become prosecution witness. So if P now become prosecution witness, now can we regard him to be an accomplice or not? Basically, you look at the case of Davis and PPP. He may be involved, participated in the commission of the crime. He bring the accused person to the and assisted the accused person. He may be the one who prepared all the weapons for the commission of the crime. He was the one who prepared the plan for the commission of the crime. However, he is not charged here. He is now being regarded as an accomplice. So when you talk about here, can P here, who involved in the commission of a crime here, become prosecution witness and give evidence for the prosecution? How do we treat his evidence? So when you talk about number one, the issue number one here will be whether he is a competent witness. You got to go back to section 118. You got to go back to section 118 whether they are competent to testify or not. Now you have to bear in mind of the fact that whenever you have an accomplice here giving evidence in the court, remember the law has to treat him with caution, because there is a possibility that the accomplice here, when giving evidence in the court, has a motive of not telling the truth because he was actually involved in the commission of the crime. There is a possibility that he is going to give evidence in favor of the authority who benefits him. So basically remember, B here become prosecution witness after he has a deal. Yeah, he has a deal with the prosecution. So he's willing to give evidence against his own friend. So he basically backstabbed his own friend. Because of the kind of person that he is, he has an interest in this particular case. There is a tendency of him giving evidence minimizing his role in the case as opposed and aggravate the role of A1 and A2 here. So the court says that you have to deal their evidence with caution, right? Because the nature of this particular person who has some kind of relationship with the accused person, he basically, right, accrued himself, okay? So when you are dealing with this kind of situation, your first issue here is whether he is competent to testify. Of course, under section 118, does he understand the question put to him? Does he able to give rational answers to those questions? If the answer is yes, then he can be a competent witness. So, and of course, when he gives evidence, he's a competent witness, he can give a relevant evidence. Remember, he can give a relevant evidence. Basically, he can tell the court of the fact that, yes, this is the incident that we have planned, we have moved like this. So his evidence definitely is going to be relevant under the law. Under section 7, right? Maybe to reflect how the incident happened, state of things. It can also be relevant under section 8 to show preparation. So basically what happened here, the accomplice here can relate to the preparation that all of them made for the commission of that particular crime. So he can also give evidence of section 6, same transaction, which reflect how which narrate how the incident begins, how the robbery begins, and how it ends. So basically, in terms of the relevancy of accomplice evidence here, of course, you have so many laws that can support the relevancy of his evidence. Yeah, all right. So he is competent. Therefore, we can conclude that this particular person is a competent witness. He is relevant person to testify in the court. Now, when you talk about competency, besides section 118 of the Evidence Act, we also have to look at section 133, because section 133 here is dealing with competency of an accomplice to give evidence in the court. Now, let's look at section 113. Okay. Sorry, section 133 of the Evidence Act. Now, when you refer to section 133, you have there accomplice. An accomplice shall be a competent witness against an accused person. So this section 113 here, the first part, basically confirmed the law under section 118, which says that an accomplice here is a competent witness and he can give evidence against the accused person, right? An accomplice is a competent witness against an accused person. And the second part of section 133 says that a conviction is not illegal merely because it proceeds upon an uncorroborated testimony of an accused person. So the second part of section 133 basically seems to suggest that, right? Accomplice, of course, is a competent witness. Accomplice evidence can be used to convict the accused person. Accomplice evidence can be used to convict an accused person even though there is no corroboration. So even though there is no corroboration, so it means that under the law of evidence, accomplice evidence here does not require corroboration for you to secure conviction of an accused person. So evidence of an accomplice here does not require corroboration. So requirement of corroboration for an accomplice evidence is not mandatory under the law. Right, under the law. So there's no need for you to have, it is not within the rule of law for the evidence of an accomplice here be corroborated. Right? However, even though the evidence of an accomplice here without corroboration can be used to convict an accused person, the cases of Sarjit Singh and the case of Anwar Ibrahim number 3 basically says that corroboration warning is mandatory. So what does it mean? It means that whenever you have and a PW here giving evidence in the court. So you basically have PW here testifying in the court. His evidence, of course, is very strong. He can give evidence clearly relevant under Section 7, Section 8, Section 6. He can give evidence of preparation as to how the incident happened, the transaction as to how it began and how it ended. So if the evidence is very strong, you can use the accomplice evidence here to convict A1 and A2, accused person 1 and accused person 2 in these facts, in this example, even though without corroboration. But when the judge analyzing, in his judgment, when he analyzed the evidence of PW1, he has to warn himself. He has to warn himself. There is no hard and fast rule as to how warning is to be administered, as long as when you read the judgment, you'll find that the court is saying that, well, I'm dealing with an accomplice here, so I have to treat his evidence with caution. That is an example of warning. So the court is actually warning himself that he has to treat the evidence of PW here, who is an accomplice here, with caution. Then that is amounting to corroboration warning. Now, why is this particular position is as such? This particular provision, the warning as to the nature or as to the issues of credibility of an accomplice here was actually given by the law itself. You have this under Section 114 illustration B. 114 illustration B, which provides you with the presumption of fact. Now let's look at 114 subsection illustration B. Now 114 is actually providing you with a presumption of fact, where the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common cause of natural event, human conduct, and public and private business in their relation to the fact of a particular case. And illustration B basically says that an accomplice is unworthy of credit unless he is corroborated in material particular. So what you have under Section 114B here is a presumption of fact to say that an accomplice here is unworthy of credit. So he is unworthy of credit, meaning to say that he is not supposed to be trusted. Because he is not supposed to be trusted, his evidence here requires corroboration. Now, if you look at these two provisions, you find that Section 114B requires the evidence of an accomplice here be corroborated. However, Section 133 here does not require the evidence to be corroborated. So there seems to be a clash between 114B and Section 133 of the Evidence Act on the need of corroboration. So in that case, how do we go about this? So basically what you find here, the Evidence Act is basically in conflict. 133 says that he's a competent witness. There's no need for you to have corroboration to convict an accused person based on accomplice evidence. But Section 114B says that he is not a credible witness. His evidence requires corroboration. Now, because of the clash between 114B and Section 113, that is why the law basically developed the need for corroboration warning, right? So that's what happened here is that because of the nature of evidence of accomplice here, and because of 114B and 133 here, the law says that you cannot convict an accused person without corroboration. However, you have to administer corroboration warning. An absence of corroboration warning may reflect that conviction can be quashed, right? So it becomes now mandatory for you to have a corroboration warning, even though there is no need for you to have corroboration, right? And of course, when you talk about, right, so that is the position of an accomplice. Now let's look at the note here. So this is basically the position. You have it under Section 118. You have Section 133 of the Evidence Act that talk about the competency of an accomplice. However, on issues of credibility of an accomplice, you have it under Section 114 illustration B that says that they are not supposed to be trusted, right? And basically, the court has a duty during examination in chief, cross-examination of this particular witness to assess, right, in the judge bench, the credibility of an accomplice when testifying in the court, whereby the court will look at the demeanor, the manner in which evidence is given, right? The consistency of the evidence given. So basically, that's how the court will need to assess the credibility. And basically, the last PowerPoint here, you find that, the last part of the PowerPoint here reflect that the case of Baskerville says that absence of corroboration warning in cases of accomplice evidence, conviction has to be quashed. So that will make it necessary for you to have corroboration warning, even though the law says that there is no need for you to have corroboration in law. So corroboration is basically, in the case of accomplice here, is required only as a matter of practice and prudence. Okay? So with this note, we complete discussion on accomplice evidence. We are going to proceed on in the next slide, in the next video, on other witnesses that require, where element of corroboration need to be discussed.